Hello Year 11s and welcome to this video on the principles of criminal law. There are 3 things that you need to do while you're watching this video. First, take the very best Cornell notes that you can. Second, use the pause and rewind functions. Use the pause function if you need to stop this video so that you can take notes. Use the rewind function if you need to go over any information contained in this video. And the third thing that you need to do is have your vocabulary sheets open in front of you so that you can write into your vocabulary sheets the definitions of key terms and of any other words the meaning of which you may be unfamiliar with. Once you've finished watching this video, please read the sections from the textbook referred to on this slide. And if you find any information from that reading that you think is useful, supplement your Cornell notes with that additional information. There are 2 separate learning intentions for this video. On this slide, I have set out the first of these learning intentions. Make sure that you write this learning intention in your Cornell notes. This learning intention is that you should be able to describe 3 things. Firstly, the elements of a crime, that is, the actus reus and the mens rea. Secondly, strict liability. And thirdly, the age of criminal responsibility, which is encapsulated in the principle referred to as Dolly Incapax. Let's start off by looking at the elements of a crime. Most crimes have 2 elements called the actus reus and the mens rea. What this means is that for an accused to be guilty of a crime, the prosecution must prove beyond reasonable doubt both the actus reus and the mens rea. The actus reus is the physical act or omission that constitutes the crime. Look down the left-hand side of your vocabulary sheets, find the term actus reus and write this definition in there. So, for example, the actus reus for the crime of murder is the act of killing the victim. This could be by shooting, stabbing, poisoning, bashing, or strangling the victim. Put another way, you can see the actus reus. That is, you can see what the accused does to the victim to kill the victim. Similarly, the actus reus for theft is the accused taking the victim's property. On the other hand, the mens rea is the state of mind that the accused must have to be guilty of the crime. Look down the left-hand side of your vocabulary sheets, find the term mens rea and write this definition in there. So, for example, the mens rea for the crime of murder is the intention to kill or cause really serious injury. And the mens rea for the crime of theft is dishonestly taking property with the intention of keeping it. Now, while the actus reus is something that you can see, the mens rea is something that you can't see because the mens rea is a state of mind or intention. However, the mens rea is critically important. For example, if Franz is walking through the bush with his gun and he shoots Hilmi with his gun, then it is Franz's state of mind that marks the difference between Franz being guilty of murder and Franz being not guilty of murder. This is because, in both cases, Franz has killed Hilmi by shooting him. That is, the actus reus is clear. However, if Franz intended to kill Hilmi, then Franz not only committed the actus reus by shooting Hilmi, but he did so with the mens rea for murder. That is, with the intention of killing Hilmi. In these circumstances, Franz would be guilty of murder. On the other hand, if Franz accidentally shot Hilmi, perhaps because Franz tripped while he was carrying the gun and the gun went off, killing Hilmi, then, while Franz committed the actus reus of murder by shooting Hilmi, Franz did not do so with the mens rea for murder. That is, Franz did not have the intention of killing Hilmi. It was an accident. In these circumstances, Franz would not be guilty of murder. The second thing that you need to be able to do as part of our first learning intention is to describe strict liability. As I've said, for an accused to be guilty of a crime, the accused must both have done the physical act or omission that constitutes the crime, that is, the actus reus, and must have committed the actus reus with the state of mind, that is, with the mens rea, for the crime. However, there are a small number of crimes that are what we call strict liability offences. A strict liability offence has an actus reus but not a mens rea, which means that to be guilty of the crime, it is enough that the accused has done the physical act or omission that makes up the crime. And it doesn't matter what the accused intended, that is, whether the accused committed the actus reus intentionally, recklessly, negligently, or accidentally. One example of a strict liability offence is serving liquor, that is alcohol, to an underage person. A person who serves liquor to an underage person will be guilty of that crime even if they believe that they are serving a person who is 18 years or over. It is sufficient for that crime for the accused to have served the liquor to an underage person, irrespective of how old that person believes the recipient of the alcohol to be. Another example of a strict liability offence is speeding. A person can be guilty of this crime even if they didn't intend to speed. For example, as where they are not watching their speedo and accidentally exceed the speed limit while overtaking a slower moving vehicle. Or where they jam their foot on the accelerator when they are stung by a swarm of bees. Again, it doesn't matter how or why the person sped, it is sufficient to be guilty of this crime that the person drove over the speed limit. Strict liability offences are generally minor offences rather than major offences because major offences are often punishable by terms of imprisonment, and it would be unfair to send a person to jail for committing an offence that they did not mean to commit. Look down the left-hand side of your vocabulary sheets, find the term strict liability offence and write this definition in there. The third thing that you need to be able to do as part of our first learning intention is to be able to describe the age of criminal responsibility. This is the age an accused must be before they can be guilty of a crime. The age of criminal responsibility is expressed by the principle dolly incapax. Dolly incapax is Latin for incapable of evil. There are two parts to the dolly incapax principle. The first part of the principle is that a child under the age of 12 years old is presumed not to intend to commit a crime, that is presumed not to have the mens rea or state of mind needed for a crime. As a result, a child who is under 12 years of age cannot be convicted of a crime. This is because the law treats under 12-year-olds as little angels who are incapable of evil. Of course, some of you who have younger brothers and sisters might well disagree with this. The second part of the dolly incapax principle is that a child between the ages of 12 and 14 years old is presumed not to intend to commit a crime, that is presumed not to have the mens rea or state of mind needed for a crime. However, in this case, the presumption is overturned if the prosecution can prove that the child knew that what the child was doing was seriously wrong in a moral sense. Put another way, a child who commits a crime when they are between the ages of 12 and 14 years old, that is, when they are anywhere from 12 years old to 13 years and 364 days old, cannot be convicted of that crime unless the prosecution can prove beyond reasonable doubt that the child knew that what they were doing was seriously wrong. If the prosecution can do this, then,
For the child to be convicted of the offence, that is, found guilty of the crime, the prosecution still has to prove beyond reasonable doubt the actus reus and the mens rea, that is, that the child did the act constituting the offence and did that act with the state of mind that is necessary for the offence. A notorious case where this occurred was the murder of James Bulger, a 2-year-old. In that case, James was abducted and brutally killed by 2 10-year-old boys. In accordance with the Dolly-Incopax principle, the prosecution first had to prove that the 2 boys knew that killing James Bulger was seriously wrong. The prosecution was able to do this because both boys had tried to cover up the fact that they had killed James, which strongly suggested that they knew that killing him was seriously wrong and that they would be in serious trouble for it. I've included a link to a video about this case on this slide, and if you want to, you can watch this video. Please also make sure that you include in your vocabulary sheets the definition of Dolly-Incopax contained on this slide.
You'll recall that I said that there were 2 separate learning intentions for this video. On this slide, I have set out the second of our learning intentions. Make sure that you write this learning intention in your Cornell notes. This learning intention is that you should be able to describe the possible participants in a crime, such as principal offenders and accessories.
There are, in fact, 3 possible types of participants in a crime.
On this slide, I will explain each of these types of participants. Make sure that you include the definition of each of these types of participants in your vocabulary sheets. The first type of participant in a crime is the principal offender. The principal offender is the person who actually commits the crime. That is, they commit the actus reus and they have the mens rea necessary for that crime. So, for example, where Adna murders Emily, then Adna is the principal offender because she is the one who actually commits the murder. Adna has committed the actus reus, say by stabbing Emily, and she intends to kill Emily, which is the mens rea for murder. The second type of participant in a crime is a person who is involved in that crime. This is a person who does not actually commit the crime, but encourages, assists, or agrees with the principal offender to commit the crime. So, for example, if Thomas held Emily while Adna stabbed Emily to death, then Thomas would be a person involved in the crime of murdering Emily. Thomas did not actually stab Emily himself. He didn't commit the murder, but he assisted Adna, the principal offender, to commit the murder. In these circumstances, Thomas will be punished as if he had actually murdered Emily. And the third type of participant in a crime is an accessory. For a person to be an accessory, 2 requirements must be satisfied. If you're asked to analyse whether someone is an accessory to a crime, then you must refer to each of these 2 requirements. The first requirement is that the person must know or believe that the principal offender has committed a serious indictable offence. For these purposes, a serious indictable offence is an indictable offence where the maximum punishment is more than 5 years imprisonment. The second requirement for a person to be an accessory to a crime is that the person must have impeded, that is, hindered or interfered with, the apprehension, that is the arrest, the prosecution, the conviction, or the punishment of the principal offender for that offence. So, for example, if Aisha helped Adna to dispose of Emily's body after Adna had stabbed Emily to death, then Aisha would be an accessory. First, if she knew or believed that Adna had murdered Emily. Murder is a serious indictable offence because the maximum punishment for murder is life imprisonment, which is clearly greater than 5 years imprisonment. And second, if Aisha had in some way impeded the apprehension, prosecution, conviction or punishment of Adna for murder. In this case, Aisha has impeded the apprehension of Adna because Aisha has helped Adna to bury Emily's body. That is, to conceal that Adna has murdered Emily, and this would help Adna avoid being arrested for murder. It is a criminal offence to be an accessory to such a crime.
Well, that brings us to the end of this video.
As a result of watching and taking notes on this video, you should now be able to do two things. First, you should be able to describe the elements of a crime, that is the actus reus and mens rea, strict liability, and the age of criminal responsibility, which is the Dolly in Capax principle. Second, you should be able to describe the possible participants in a crime, such as principal offenders, persons involved in a crime, and accessories. However, we haven't finished yet. There is just one more slide. Because we are looking at criminal law, I want to remind you about the roles of the judge and jury in a criminal trial. They have two roles each. First, the judge directs the jury as to the law to be applied to the case. Second, the jury determines the facts. That is, the jury decides what evidence to believe. Third, the jury, after it's looked at all the evidence, decides the verdict, that is, whether the accused is guilty or not guilty. And fourth, if the accused is found to be guilty by the jury, then the judge determines the punishment to be imposed on the accused. This might, for example, be imprisonment, a community correction order, or a fine. Now remember that there is only a jury in the county court or the Supreme Court. That is, there's only a jury for indictable offences. In the Magistrates' Court, which hears summary offences and any indictable offences that are actually heard summarily, there is no jury. As a result, it is the magistrate who decides what the applicable law is, who determines the facts, who decides the verdict, that is whether the accused is guilty or not guilty, and who determines the punishment for the accused if the accused is guilty. In the county court or Supreme Court, where there is a jury, the jury will consist of 12 members who are chosen at random from people who are 18 years or over and are registered to vote. For an accused to be found guilty or not guilty, the jury's verdict must be unanimous. That is, for an accused to be guilty and convicted, 12 out of 12 jurors must agree that the accused is guilty. This means that 12 out of 12 jurors must be satisfied beyond reasonable doubt that the accused is guilty. And for an accused to be not guilty and acquitted, 12 out of 12 jurors must agree that the accused is not guilty.
However, except where the accused has been tried for the really serious offences of murder or treason,
if the jurors cannot reach a unanimous verdict, then the judge will accept a majority verdict. This means that the accused will be guilty and convicted if 11 out of the 12 jurors agree that the accused is guilty, or the accused will be not guilty and acquitted if 11 out of 12 jurors agree that the accused is not guilty. Note that a majority verdict does not mean that more than half of the jurors think the accused is guilty or, on the other hand, not guilty. It means that 11 out of the 12 jurors think that the accused is guilty or, on the other hand, not guilty. If the jury cannot reach either a unanimous verdict or a majority verdict, then the jury is referred to as a hung jury. The accused is neither guilty and convicted of the offence or not guilty and acquitted of the offence. Instead, the accused is free to go and receives no punishment because they haven't been found guilty. In these circumstances, the Crown can choose to prosecute the accused again in front of a new jury, but the Crown doesn't have to do this. Look down the left-hand side of your vocabulary sheets, find the terms unanimous verdict, majority verdict, and hung jury, and write these definitions into your vocabulary sheets. Well, that brings us to the end of this video. Thank you for your attention.